Yeah, that's right. And first of all, I would like to express my greatest gratitude and also thank you very much for joining the panel. As Professor mentioned, the title of the panel is Discovering Tomorrow's Workplace. And today I would like to elaborate, I mean, with you, of course, together about like how it's gonna be within the tomorrow's workplace, with a specific focus on the technical development and, of course, right to privacy, surveillance, monitoring of employees. And during my presentation, I would like to present you some takeaways from the research that I've conducted with my supervisor, Dr. Michał Barański, about the monitoring of psychological and emotional states of workers, with a special focus under the EU law, with a special focus on the GDPR. So first of all, I will make a short, briefly introduction to the topic, then I will move to the notion of sensitive data and its implications for the psychological and emotional state of workers. And then I will move to the categorization of psychological testing, on the one hand as a occupational health and safety tool, and on the other hand as some kind of human management tool. And then I will move to the conclusion, which is not gonna be like typical conclusion, so putting everything in a nutshell. During the conclusion I will present you some delegate referenda remarks that could be used as an initial basis for some kind of development of the regulation on that issues. So when we are starting, first of all we need to somehow define what is employee monitoring. And we can define it as an activity of the employer that allows him or her to observe employees by various means. Also, this kind of statement is supported from the side of the ILO, ILO made soft law, so the Code of Practice on the Protection of Workers' Personal Data. However, the forms of monitoring and also its targets are changing as the nature of the manufacturing and labor changes. For example, we can think about such a new management theories as total quality management. For example, Miłosz will elaborate about it a little bit later. Also, just-in-time production. That is putting more focus on the quality and also more focus on the monitoring as a tool to manage workers within the workplaces. Currently also many corporations, many employers are using very detailed systems to obtain data about, for example, employees' activity, measuring their workplace, also breaks during the performance of the work. And this collected data is often analyzed with the help of specific algorithms to assess the efficiency and also quality of the performed work. For example, by obtaining the data on the basis of the employee's tone during the conversations. The same is also the checking the messages via corporate messaging systems to, for example, like indicate to find out what is the mood of the employees. And moreover, the changes in the employment are placing very strong emphasis on the digitalization, and digitalization is linked to the growing number of higher skilled professional occupations. So, and that resulted in the demand of a more stress-resistant workforce. The question is how to recruit this kind of workforce and how to train it in the future. Basically, the mean to do it is the growing number of psychological testing of employees. As a great example of this are some so-called team building games within the workplace. Of course, the main aim of these team building games is to somehow find out the skills for cooperation, for working in the teams within the workforce. However, it could also happen that during these games, employees and the specialists are obtaining data, for example, about personal traits, the psychological traits of employees. For example, is the employee argumentative? Which of the employees has some kind of leadership skills? Yes, and of course we can also mention that psychological data are more and more frequently gathered by like, specific techniques, for example, like brain-computer interfaces, by specific devices used for self-tracking purposes. However, today I would like to focus mostly on like this kind of traditional psychological testings because these are raising a lot of inconsistencies within the discussion about the employment, and I think it's just a good topic to focus on. So we know that psychological tests could take various forms, as for example tests of attainments, personality tests, ownness tests, and a common feature for all of these tests is that they're processing mental data. The question is, what is mental data? And two authors, the Marcelo Jenka and also Guancaldio Malgeri, find out that they define the mental data as any data that can be organized and processed to deduce an individual's mental states, including their cognitive, affective, and connotative states. They also defined mental state as any conglomeration of mental representations and propositional attitudes that corresponds to the experience of thinking, remembering, planning, perceiving, and feeling. And following these definitions, we can directly understand that emotional states and psychological states are covered by these definitions. And here on that graph, we can see the general shape of the psychological state. So we can see that psychological state basically consists of cognitive state, behavioral state, and emotional state. I'm not gonna give you now the definition of psychological state because it's pointless to do it. However, I would like you to remember that emotional state is something much more detailed than the psychological state, because emotional state we can define as a particular mental condition that occurs during the life of the subject and defines not only the level of information, energy metabolism, but also focus, behavior. So emotional state is more linked to the person's character, activities, and personal traits. And this distinction is very relevant in the context of the Article 9 of GDPR. All the story behind the Article 9 begins like that in the Recital 71 of the GDPR preamble, that Recital highlights the necessity to safeguard personal data in a way that prevents discrimination against natural person based on, and among other things, health status. So first we have like the mentioning of the health status. And the answer for this necessity was the Article 9, paragraph 1 of the GDPR, that established the catalog of sensitive data, which processing is in general prohibited, and sensitive data are data which may reveal, among other things, data concerning health. And again, we can see that here the mentioned are like the health-oriented data, and I would like to attach your attention to that because, in my opinion, health-related data is the category that is most closely related to the data obtained from the psychological and emotional states of workers. And the same is also mentioned in the Article 4, paragraph 15 of the GDPR. That's the definition of the health data. Also, among other things, mental health is mentioned there, not only physical but also mental health. The same is also with the Recital 35. It is also mentioning mental health as a part of data that may reveal information about health. So we can see that due to these definitions, every piece that is related to mental health or that may reveal information about mental health should be considered as a health-related data. So there is no doubt that psychological state will be covered by these definitions. However, on the other hand, data connected to the emotional state won't be covered by these definitions, but that does not mean that data concerning emotions are not sensitive data. It is also common practice among employers to somehow detect emotions of employees through specific biometric systems that are, for example, tracking the facial expressions of employees, and then this kind of data will fall under this article as a biometric data. However, the question is if it's even at some point possible to also process this kind of data, sensitive data. And the question is yes, it is possible, because the prohibition from Article 9, paragraph 1 is absolutely not absolute. So paragraph 2, letter B, states, and it's most important for us today, that the prohibition of sensitive data does not apply if it's necessary for the purpose of carrying out the obligations and exercising specific rights of the controller of the data subject in the field of employment and social security and social protection law. So it is directly connected to the occupational health and safety. Of course, this provision is very general and it should be specified on the level of the member states. And so, as we already know, the processing of sensitive data is under certain conditions admissible. Moreover, this issue is on the forefront of the agenda of European Union since 2005. That was the year when the Commission's Green Paper on the improving mental health was issued. And despite that does not like explicitly mentions terms like psychological risks and mental health, there is a possibility to introduce within the workplace, within the employment, some kind of obligatory psychological testing, owing to the Council directive on the introduction of measures to encourage improvements in the safety and health of workers at work. Because that in that directive we have Article 5, Paragraph 1, that states the employer shall have a duty to ensure the safety and health of workers in every aspect related to work. And that's this indirect possibility to introduce some kind of obligatory psychological testing. Also, of significant relevance in that context is the Article 9, Paragraph 2, letter H of the GDPR, that states that processing of sensitive data is possible if it's necessary for the purposes of preventive or occupational medicine. However, nevertheless, we need to remember that obligatory psychological testing, so like arising directly from the law, is not possible within the notion of psychological testing as a human resource management tool, because this psychological testing as a human resource management tool can be only optional, and at some point it is even permissible under the scope of the GDPR. But the question is it possible to indicate or to introduce some kind of like mechanism of psychological testing in every situation? And the answer is no. And well, what a surprise. The great example for this is the directive on the platform work. Because the directive on the platform work in this current, we discussed it yesterday, yes, indicates in the Article 7, Paragraph 1 in the letter A and E that digital labor platforms shall not by means of automated monitoring or decision-making systems process any personal data on the emotional or psychological state. So we can see that some kind of switch from the side of the EU drafter, that in that act they decided to explicitly mention emotional or psychological state. It is also mentioned in the letter A, also in the Article 12, Paragraph 3, that is mentioning some undue pressure on the platform workers and also risk on the safety and physical and mental health of platform workers. However, the question is, because it is explicitly mentioned in that directive, and it is justified that the group of platform workers is vulnerable to like some higher extent. And my question is it really true that only platform workers are vulnerable to that scope? They need like explicit cover of these issues within this directive. I think that there are also other occupations that are vulnerable at that same level as platform workers. So I can see some kind of inconsistency in the approach of EU drafter. And before I will move to the conclusion, I would like to also mention two other controversial issues on that basis. First of all, consent. Consent as a basis for psychological testing. So we know that consent under the scope of the GDPR can be a basis of processing sensitive data. But now we need to think about like the nature of the employment relationship. What is like the most important feature? Dependency. Yes, there is unequal position between employer and the employee, because resulting from the general dependency, also from the economical dependency, and with that topic is also strongly connected the notion of the employer's information advantage. And myself, in my opinion, also in my opinion of my supervisor, which is also quite surprising, we support this kind of point of view of the doctrine, that regulation on consent should not apply to the employee's data, and that's it. The other issue is the covert monitoring, because some psychological tests for reliable results require covert conduction. As I said, for example, during this teamwork games or team building games, if workers will know that they are monitored under the perspective or their psychological and emotional traits, I mean, they would absolutely behave in a different manner, yes? And under the GDPR, covert monitoring is generally prohibited. However, we have some kind of level of discretion for the member states because of the Article 23, also 88 of the GDPR. However, in my opinion, there is absolute lack of proportionality in that case. Because on the one hand, we have employment relationship, which is like, as I said, employees are kind of like a vulnerable group in the society, and also processing sensitive data of the employees is like absolutely excessive. The conclusions. So I prepared some 6 de lege ferenda remarks. And well, I will be also critical during this de lege ferenda remarks that I figure out with my supervisor, but in a moment I will tell you why. So first remark is the inclusion of psychological testing in the EU directives. I think that amendment of the EU health and safety directives to explicitly cover psychological testing may somehow ensure the uniform framework and clear workplace standards across the member states. The second is the unification of definition of psychological and emotional states. I think that it would be kind of good idea to explicitly define the psychological and emotional states, because we have these notions already in the legislation, but we don't know what does it actually mean, like in detail. The third remark is enhancing protection from sensitive data, and that would cover like classifying emotions and thoughts as sensitive data, because that will ensure the highest level of the protection. Fourth is restricting employee monitoring scope. I think that would be a good idea to restrict employee monitoring scope only, of course, when it comes to the psychological testing, only to some essential scenarios, such for example sobriety tests or like safety tests, health tests, and checkups and things like this. Fifth is the standardization of privacy rights on EU level. I think that somehow, maybe not a unification, but harmonization of the meaning of the right to privacy would also deliver employees with the higher level of security, and it would also support free movement of workers, which is one of the essential trait from the treaties in that context. And the last one is introducing limitations on consent for sensitive data. I've already mentioned it. It's the exclusion of the employee consent as a basis for processing their data. However, my problem with these remarks, but generally with this kind of approach, is that it's a very EU-centric approach. And my concern is like this. What if EU will regulate that issues in that manner that there will be possible too liberal interpretation of the provisions? That will, in my opinion, result some kind of pushback from the side of the member states, which will cause even further inconsistencies in that field. And well, maybe at some point, someday, I would like to focus more on like finding out or working out some kind of answer for these issues from the side of member states by detailed regulation of member states, not only by EU drafter. Because as we also mentioned during Pana's Trouble, regulating this kind of issues can also result in the regulation of topics that are absolutely not within the competences of the EU, as we, for example, mentioned about the employment relationship and the definition of the employment. So yeah, more or less that's it. These are like a few insights from my research that I conducted, and I hope that we will have some kind of fruitful and thought-provoking discussion about it. Thank you very much.